Good afternoon, friends. One of the important judgment from the perspective of arrest in GST. Question is, when arrest is legal, whether it is violative of Article 21 to the Constitution of India, protection of life and personal liberty. Even though arrest sometimes said to be legal, but is it necessary in all cases to arrest the accused when charge sheet is already being filed? One of the judgment coming from CJM, Chief Judicial Magistrate Court, Gurugram, in the case of CGST versus Yogesh Gupta. Very interesting judgment. Revenue has filed the remand application under section 167 CRPC, read with section 187 BNSS Act, Bharatiya Nagrik Suraksha Sanhita Act 2023, for remand of accused in GST for the 14 days. So the accused has represented before the CJM court and stated, Lordship, the ground of arrest was not properly intimated to me. Just for the sake of information, they have given the information and got it signed in arrest memo. So it was not properly communicated. Even the ground of arrest is not sufficiently disclosing what is the offense he has committed, nature of the case. Third is very interesting and important. On that basis, this judgment has come. Before arresting an accused, it is important, compulsorily mandated, as per section 41 and 41A of CRPC, Criminal Code of Procedure 1973, read with section 35 of VNSS Act 2023. And what is important, a notice to be issued to the accused before arresting when offences are punishable for a period not exceeding 7 years. So notice need to be issued to the accused before arresting. This was not followed, and that is the reason it is being stated and prayed before CJM court that this arrest is illegal. It is not legal. This was the defense taken by the accused, who was in custody, for which remand application was filed by the tax department complainant for 14 days. What department, GST department has contended, they have said that we have arrested the accused under section 69 of CGST Act. And CGST Act is a special act. So any provision which is coming from CRPC, like section 41 and section 41A of CRPC, read with section 35 of BNSS Act, is not applicable. So if notice is not issued to the accused before arresting, it cannot be said that this arrest is illegal. It is legal as per section 69, read with section 132 of CGST Act. This was the ground taken by the tax department before CJM court. What Honorable CJM court, and very interesting one, we have seen in number of cases which is reaching before CJM court. Majority of cases we have seen that the accused is remanded to the custody for the revenue, for custodial interrogation, But this case is a unique one, and what CJM Court has held and concluded, interesting one, hue and cry in the market. Honorable Court has said, if we look at the Apex Court judgment in the case of Ernest Kumar versus State of Bihar, wherein Apex Court has held that Section 41 and Section 41A of CRPC, read with Section 35 of BNSS Act, is mandated, means notice to be issued to the accused before arresting him wherever offences are punishable, and offences are punishable for a period not exceeding 7 years. If we look at the Punjab and Haryana High Court judgment in the case of Akhil Krishan Mungu, it is being stated and quoted in the judgment that number of provision of CRPC are being considered even in GST law. Reference can be drawn under Section 67 subsection 10 of CGST Act, Section 69 subsection 3 of CGST Act, Section 132 subsection 4 of CGST Act, where reference of CRPC is existing. Alongside Section 70, where summon is issued under GST law, it is being considered as a judicial proceedings under Section 193 and 228 of Indian Penal Code. So it can't be said, as contemplated by the GST department, that Section 41 and 41A of CRPC, read with Section 35 of BNSS Act, is not applicable for the GST law. It is applicable even for the GST law. Since notice is not issued to the accused before arresting, as per this provision, that is, the region arrest is illegal, it is not legal, and custody, remand back cannot be granted. This is what held by CJM Court. Having said that, now it is very interesting and important for all of us to understand. Recently, Honorable Supreme Court, while giving judgment in one of the case, has made comment, even if arrest is legal, but it does not mean that compulsorily arrest to be made. Even though arrest is legal, they must follow strict guidelines and procedure. And that is what being considered by CJM Court, that the special guidelines and procedure for arrest, because it can violate the protection given under Article 21 to the Constitution of India, which is pertaining to life and personal liberty. And what Apex Court has said in one of the case, when charge sheet is being filed, why arrest is necessary unless it is being demonstrated that department need custodial interrogation, or they feel like there is heinous crime, or they feel like that influencing can be done by accused to the witness, or maybe chances of absconding of accused person. When the accused is willing and cooperative with the department for their investigation, even though arrest is permissible, why arrest to be done? Having considered this, recently one instruction in GST law, instruction number 1 dated 13 January 2025, it is stated that whenever any arrest is being made under GST law, accused person must be intimated ground of arrest. And this instruction clearly saying that ground of arrest is something different with the region of arrest. So these are two different things. There may be number of parameter which may be alleged for the region of arrest, but cannot be a ground. So ground of arrest must be intimated. and relied upon two apex court judgments, Pankaj Bansal and Prabir Purakyastha. So, Delhi High Court relying apex court judgment has said ground of arrest must be intimated to the accused person. So, why this video? Important. In GST, we have seen that the kind of coercion, threatening, duress at the time of inspection and search. We have seen the department usually give threatening that we will arrest you and revenue is being collected, which is not voluntary. Let me tell you, within GST law, there is no provision of advance GST payment unless it is voluntary. Whether you look at 73 subsection 5, non-fraud case, 74 subsection 5, fraud case. Now both 73 and 74 will lose relevance from financial year 24-25. Now it is 74A. There is no provision of advance payment of GST unless it is voluntary. So if department is putting coercion, duress, threatening of arrest, there are a lot of subtle judgment by Apex Court, D.K. Basu guidelines when arrest. Bail is the rule, jail is an exception. That is what we have understood. Arrest should be taken as a last resort. It cannot be given at the first go. And this money which gets collected, revenue collection, in the name of revenue collection, to what extent it is correct? We have to be accountable both ways. Tax evaders must not be left free. At the same time, the authority should not create any coercion and duress just because of revenue collection and giving threatening of arrest. You must know then what are the provision in GST law for arrest. Section 69 giving power to the commissioner to pass any order for the arrest of any person whoever has committed or causes to commit and retaining benefit out of it for 4 specified offences. 132 subsection 1 clause A, supply of goods or services or both without invoice, cash sale. Clause B, issuance of invoice without supply of goods or services, fake invoice with no underlying supply of goods or services. Clause C, on such fake invoice, credit is being availed, wrongly availed and utilized. Clause D, GST collected but fails to pay within a stipulated time period of 3 months. And if amount of tax which is being evaded or wrongly availed ITC or utilized or erroneous refund is more than 2 crore, arrest order can be passed by the commissioner. But section 132 is talking about what is bailable offense and what is not bailable offense. Non-bailable offense or cognizable offense only when threshold is more than 5 crore and punishable with fine and 5 years of imprisonment. And thereby for this provision, offences punishable for 5 years imprisonment, thereby section 41 and section 41A of CRPC, Code of Criminal Procedure 1973, read with section 35 of BNSS Act is applicable. So what is important? Notice to be issued to the accused before arresting. It is mandated. Supreme Court, Apex Court judgment is being relied upon by CJM Court and said whatever arrest is being made, it is without issuance of notice before arresting the accused, which was mandated as per the stated provision. Thereby, this arrest is illegal and need to be released. No remand back would be permissible. Having said, less than 5 crore threshold amount, tax evaded, wrongly availed ITC or utilized or erroneous refund less than 5 crore are being considered as a bailable offence, where bail can be granted by the GST Deputy Commissioner, bailable offence. So this video was meant to alert both right of a taxpayer whenever arrest is being done, whether it is as per the law or not, whether it is violative of Article 21 to the Constitution of India, protection of life and personal liberty. Third, even though arrest is legal, but whether strict procedures are being followed or not followed. Whether arrest is compulsory even though it is legal, unless you need custodial interrogation. Heinous crime. You think as a department that he will influence the witness, or there are chances of absconding of accused. But whenever he is coming forward and cooperating with the investigating team, and he is appearing before the court whenever court is asking, he is appearing before the authority when authority is asking why he should be arrested, he should be granted a bail. And once charge sheet is being filed, why arrest is being done? This is the question raised by none other than Apex Court, Supreme Court. But this important judgment, which I thought let me draw your attention. And from department perspective, quite important. Yes, whenever there is a tax evader, he must not be set free. But just because we are looking at tax evader, there should be concrete document material within the hands of department stating that he is the accused. Just on apprehension, suspicion, can we proceed with the arrest? Please try to appreciate, get into the shoes of a person. If you arrest such person who later turn out to be not accused, he loses his reputation, goodwill in the society. Then what is the protection of Article 21? And who is supposed to provide this protection? We all are equally responsible to make this nation proud. So let's do and do better. We are all accountable for the nation growth and development. So we must take the responsibility from both sides. No tax evasion, but no coercion and no duress, threatening of arrest. Let's walk the talk and make ease of business, which is utmost important for all of us together. Thanks for watching. Stay tuned. Thank you very much.